I'm going to explain to you why I gave you June 6th. I was told by the board that the matter was scheduled for June 6th. It wasn't until I was told by the board when I called the board that the date was scheduled for June 6th, and I passed that information on to you. It was not until when I came to the actual location that I was told, looking at the document, that it's actually June 5th.
And did you send them an email to say that you were?
I was advised by the board that he was also going to be receiving a copy of the notice from the board in regards to the information. The point is that I was prejudiced by not having my matter heard sooner in April because this man was out of the country. So that was a prejudice against me.
You can pick your own date and show up whenever you want.
No, I'm saying that I was ill on that date, and it wouldn't have been in my best interest to delay the matter because it's a matter that I wanted to have heard sooner because of the circumstances around this case. And as a member, you have no right to go back to some previous landlord and some previous address which has no bearing on this matter before the board today and use that in order to prejudice me in this hearing. That's completely biased against me. No, what happened in regards to this application, if you look at the entire circumstances, the tenant was inconvenienced by the landlord because he did not comply with fire code regulation. The tenant was removed from her home. So all of the circumstances around here in this application is something that the tenant wants to be heard as soon as possible. It would not be in the tenant's interest not to have the matter heard on the 15th because the tenant's been waiting since March to have this matter heard. So the fact that the tenant could not attend the hearing on the 15th through no fault of her own because she was sick. And if the tenant, obviously, this also has a bearing on this application today in regards to the review, the fact that the board considered the fact that the landlord was out of the country and inconvenienced the tenant by giving her a future date for May 15th.
Okay, all right.
So what I'm asking the board is to be fair because the tenant was already prejudiced in this matter by having the application heard in May 15th.
So essentially, the board gave me the opportunity to proceed to your case. I was the one that wrote in the first review that the best approach, since you can't be put back in the unit, is to make your claim to whatever compensation
And that's something I want to mention to the board today. The landlord is claiming that I'm not entitled to any compensation. I had a conversation.
He's entitled to dispute that. So, but that was what the hearing was for. But you've taken the approach that you didn't get it your way, and so you would do it your way.
No, I've taken the approach that I was sick and unable to attend on that day, and I can't take that back because that's the fact. Okay? So if the board don't want to consider that, then it's up to the board. The board needs to be fair and to understand the fact that the tenant application was already delayed because of the board accommodating the landlord in the month of April. The tenant wanted to have her matter heard in the month of April. The board gave her a date for May 15th. So the fact that the tenant had to come back in May when the matter was of such an urgent matter to deal with this situation sooner, the tenant would not be thinking, okay, I don't want to attend this hearing in May because she's already, this is not a situation where the tenant is being evicted and is in her home. This is a situation the tenant is put into a very just horrible situation by the landlord. So it's not a situation where, you know, if the matter come back any old time, it's okay with the tenant. This is a matter that the tenant wants to have dealt with ASAP because of the circumstances around her application. The fact that she's not living in her home, and it's the landlord's fault and why she had to be removed from the fire services and all the things. So the board, to be fair to the tenant, has to look at all of the circumstances and why would the tenant not want to attend on that hearing, on hearing date, when she's been waiting for since March to have this whole thing heard because of the circumstances when she filed the original application on March 27. The other thing is that because the landlord was out of the country in April, you made an order in regards to compensation which the tenant can seek, whatever, and the tenant's property, the landlord has not even allowed the tenant to get her property back. So there's a whole lot of issues that the tenant has outstanding that she needs a hearing ASAP. And, you know, at one point I spoke with him, he says, yes, you can come and get your stuff. Another point is, I don't have the time, and he's giving me all kind of, you know, reason why he can allow me to get my things back, and I've been out of my unit. And when does the board concern about the tenant's property or the tenant rights or the fact that the tenant could not be in her home? And, you know, all of these things need to be dealt with ASAP.
You're entitled to file your application, and that's exactly what you did. You were given a hearing, and the hearing started. You don't pick and choose when to attend. So you don't get a new hearing because you decide that you don't like May the 15th after all.
That's not the argument that I'm making today. I'm saying that I was not able to attend the hearing on the 15th because I was unable to attend the hearing on the 15th. If this argument was made in a court of law, it would have been accepted. And the board is far less than the court. So as far as a fair hearing, as far as the fairness to the tenant, the board need to consider all of the circumstances. One of the circumstances I'm asking the board to consider, which you're not prepared to do, obviously, because there seems to be a presumption of bias on your part, because you're already going into other cases that has no bearing on the matter today. Okay, I was asking the board today to consider the fact that the board had already prejudiced the tenant by delaying the matter until May 15th. Okay, so the fact that the tenant was asking for a date sooner than May 15th should show that this is not a matter that the tenant wanted to not hear ASAP as soon as possible. Okay, so why would the tenant want to have her matter heard as soon as possible because of the circumstances that she was put in by the landlord? And you keep rolling your eyes, and really, I find it extremely offensive because you don't do that when the landlord is speaking.
I don't.
Okay, you're doing a number of things that I find extremely offensive.
But look at your own eyes. Your eyes are moving.
No, but
so
I am not. I am not rolling my eyes,
okay,
looking up at the ceiling.
So my eyes should never move.
Well, you don't do the same thing when the landlord is.
I have to move my eyes around, and, and you know, from, as I told you, from the paper, look at your face. Look at everybody else.
I didn't see you make that same expression
I
when the
have
landlord
no
was speaking.
I have no control over your impressions, but I'm not satisfied.
I'm saying that your demeanor.
I'm not satisfied that you had a medical emergency because you have nothing to show for it, and the evidence in the file and from your previous proceedings is that you don't like it when you don't get your way, and that's all that there is to it. So I'll dismiss the review. Okay. So that's it.
You came here prepared to dismiss review, and it doesn't matter because the tenant will now go and file an application and have this matter heard. This is not the end of the matter.
Okay, that's fine.
Okay, but it's also not fair for you to be doing what you did in this hearing.
Okay, thank you.
Yeah.
I'm
going to explain to you why I gave you June 6th. I was told by the board that the matter was scheduled for June 6th. It wasn't until yes, I was told by the board when I called the board that the date was scheduled for June 6th, and I passed that information on to you. It was not until when I came to the actual location that I was told, looking at the document, that it's actually June 5th.
And did you send them an email to say that you were mistaken?
I was advised by the board that he was also going to be receiving a copy of the notice from the board in regards to the information. The point is that I was prejudiced by not having my matter heard sooner in April because this man was out of the country. So that was a prejudice against me.
You can pick your own date and show up whenever you want.
No, I'm saying that I was ill on that date, and it wouldn't have been in my best interest to delay the matter because it's a matter that I wanted to have heard sooner because of the circumstances around this case. And as a member, you have no right to go back to some previous landlord and some previous address which has no bearing on this matter before the board today and use that in order to prejudice me in this hearing. That's completely biased against me.